individuals in the dwelling house at the time of the invasion and the use of acts to suppress those individuals so that other criminal acts can be committed. The approach aligns with the legal trends observed in other Commonwealth countries. The penalty for the offense of home invasion is aggravated by two factors, namely, and again we make no apology for this, where the accused is a gang member, this government is at war with the gangs. And we are encouraging those who are involved in gang-related activity. We are encouraging all of those who are involved in gang-related activity to find something else to do. We are going to concentrate on them, and we are not going to let up. We have started it. It will not end until they... So it's aggravated where the accused is a gang member or participant in an organized criminal activity. The offense is also aggravated where the victim of the offense is a child, a senior citizen, a person with a disability, or part of the vulnerable population as defined. Again, we make no apology for this. Clause 6 provides for the right of self-defense as a lawful demonstration by an occupier that he is standing his ground against an invader. It sets out the circumstances under which the court would exercise its jurisdiction to determine whether defensive force was lawfully used. These circumstances include the necessity of using force, the nature of the force used by the invader, the use of weaponry against the occupier, the nature and history of any relationship between the invader and occupier. The necessity rule, we think, legitimizes the defense. Mr. President, the government feels there are other clauses 7, 8, and 9. I'll just take you quickly through 7, 8, and 9. Clause 7 introduces the new concept of defense of property as a... 8 minutes. I was trying to speed up. I think I can manage. Clause 7 introduces a new concept of defense of property as an exception to the duty to retreat. The clause effectively extends the exception to the duty to retreat from the occupant's right to life to include his right to property. As under Clause 6, the occupant can use or threaten to use force or take any other action he honestly believes to be necessary. Clause 8 legalizes the actions of an individual who, acting in good faith, defends the occupant of a dwelling from a home invader, provided that the invader is in the course of attacking or has threatened the occupant. Lastly, Clause 9 provides for 6 circumstances where an occupier may not be able to claim self-defense or defense of property where a home invasion has occurred. The provision acts as a safeguard against abuse of the claim of self-defense and, by extension, the criminal justice system. The 6 circumstances are as follows. Where the individual against whom defensive force had been used or threatened had a right to be in or was shown to be a lawful occupant in the dwelling house. Where the degree of force used by the occupant or person assisting the occupant is grossly disproportionate, where the occupant or person assisting the occupant who uses or threatens defensive force is engaged in criminal activity or is using the dwelling house for further criminal activity, where the individual against whom the force is used or threatened is a member of a law enforcement authority acting in lawful execution of his duties, where the occupant or person assisting the occupant who uses or threatens the use of defensive force knew or should have known that the individual entering the dwelling house was a law enforcement officer, where at the time of the alleged home invasion, the occupant's mental faculties were substantially affected by voluntary and non-therapeutic consumption of a drug. Mr. President, there are other matters that I expect will be raised during the course of the debate. I leave aside for the moment the constitutionality concerns raised by the Law Reform Commission. They're an independent body. I asked them to do a job. It was their job to flag that there were possibly constitutional concerns. I felt that there were not. I sought advice on that question. I'm comfortable that the cases of Suraj, Achille Charles cover us, and that the legislation before us is properly before us without the constitutional right. And Mr. President, finally, I should just like to put on record that this bill is not our only answer to serious crime and to home invasion. We have made steps and are continuing steps to reform the police service, from the leadership to operations. We have made steps insofar as that is constitutionally possible to encourage our colleagues in the judiciary to reform, to pursue the appropriate reforms to ensure that trials take place within a short space of time. We intend legislation to guarantee that individuals would have a constitutional right to trial in a short space of time. We also intend to bring legislation to protect victims. A victims' rights charter is on the books, and there are other pieces and tools which we intend to deploy, which will treat with this matter. This is not a one-stop fix-all policy. There are other matters to be dealt with, including the liberalization in a reasonable way with access to firearms and other forms, other methods of defending oneself. Mr. President, with those words, I beg to move.
Honorable Senators, I shall now propose the question for debate. The question is that a bill entitled "An Act to Establish the Offense of Home Invasion," and in that context to provide that a person has no duty to retreat when acting in self-defense or defense of his property, and to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house and to provide for related matters be now read a second time. I recognize the Parliamentary Secretary in the Ministry of the People, Social Development and Family Services.
Mr. President, honorable senators, a man's home is his castle. We stand today at a legislative crucible, tasked with nothing less than restoring the fundamental contract between the state and the citizen. The assurance of security within one's own domicile. The debate surrounding the Home Invasion, Self-Defense and Defense of Property Bill is not merely a legalistic exercise. It is a profound moral response to a crisis of domestic terror that has gripped the soul of our nation. It is a declaration in the clearest possible terms that the home, the castle of a citizen, is inviolable, and that the victim of a home invasion shall not be treated by any stretch of judicial or prosecutorial imagination as the second victim of the state. The sheer volume of discourse this bill has generated across Trinidad and Tobago, from the most formal parliamentary chambers to the most vibrant and vocal mainstream social media platforms, underscores its critical importance. Citizens are not just talking, they are pleading for legislative affirmation of their inherent right to survival. They are demanding a legal framework that shifts the moral and legal burden back onto the criminal, away from the terrified homeowner who acted instinctively in a moment of unimaginable peril. The time for hesitant legal niceties is long past. The time for decisive action, for legislative courage, is now. Mr. President, the Law Reform Commission, in its comprehensive policy paper of July this year, meticulously documented the genesis of this bill, a rash of home invasions across Trinidad and Tobago. Even the language is stark. A rash, an epidemic, a systemic affliction upon the body politic. The Commission noted that the traumatic accounts of being tied up, threatened, and beaten by bandits, and most tragically, that some citizens have even lost their lives in home invasions. That's a gentle, eloquent way to say that dozens of us have been hurt and killed, or worse, watched our loved ones as they were hurt or killed, watched the life leave their eyes. And for what? For someone to grab away material things they did not earn? The Home Invasion Bill 2025 is not a piece of capricious, reactionary lawmaking. It is a deliberate, well-researched, and long overdue legislative prophylaxis against a demonstrable social ill. The existing legal architecture, relying primarily on common law principles of self-defense and the Criminal Law Act, has been found wanting. It is an established fact that currently a householder, after defending their family and property from an armed and masked intruder, often finds themselves in a police station, compelled to defend their character, their actions, and ultimately their freedom against the very state they presumed would protect them. The law, in its current interpretation, often demands a psychological composure from the victim that is simply biologically impossible when staring down the barrel of a gun in the middle of the night. To ask a victim to perform the calculus of reasonable force in that split second is not merely unreasonable, it's an act of intellectual cruelty. The bill addresses this deficiency directly in Clause 4 by stipulating that with crystal clarity that an occupant of a dwelling house has no duty to retreat from a home invader and has the right to stand his ground and use defensive force. This is the very core of what the law must provide, an unambiguous shield for the innocent. We are not legislating a new right. We are codifying an ancient, universally accepted principle of the castle doctrine, elevating it from subtle, often contested realms of common law into decisive, immutable certainty of statute. Mr. President, we stand here today to give citizens the right to stand their ground in their own homes. The opposition seems instead to stand on the duty to retreat, where they reside comfortably in their well-guarded towers, harboring an utterly impractical vision of conflict resolution in a home invasion scenario. They suggest, with demure sarcasm, that one might expect from a less informed critic, that the homeowner, upon being confronted by an armed assailant, should politely request leave to exit their own dwelling, perhaps offer a choice of their valuables as a gesture of goodwill before making a swift and strategic withdrawal. This notion is not only absurd, it is demonstrably divorced from the terrifying reality of modern home invasion. Retreating in one's own home is not a de-escalation. It is an act of tactical foolishness that hands every possible advantage, knowledge of the layout, speed of movement, proximity to family members, to the invading criminal. The duty to retreat is a doctrine that works perfectly in the tidy, hypothetical world of a courtroom, yet collapses instantly when confronted by the blunt brutality of a reality of a masked man wielding a gun at the foot of their child's bed. The Law Reforms Commission's reference to similar legislation in robust Commonwealth jurisdictions, such as England and Wales, Ireland, and Canada, confirms that the abandonment of the duty to retreat within the home is an internationally accepted, pragmatic, and moral response